Good afternoon, everyone. Thank you for attending today's webinar on Proposition 64 presented by Ed Grutzmacher and Sarah Queter. This is our third installment of a six-part series. We hope you join us for the next webinar, which is on January 4th. A schedule of our full Proposition 64 webinar series is available on the last slide of today's presentation. A couple of housekeeping items. First, all of your telephone lines are muted. If you would like to ask a question, you have a Q&A box at the top of your screen. Please type your question in this box. Ed and Sarah will be holding all questions until the end of the webinar. We have a lot of folks registered today, so if your question isn't answered, Ed or Sarah will follow up with you after the webinar by email or phone. We are also offering CLE credit for this webinar. If you check the box on the registration form to receive credit, a CLE form will be emailed to you. We will also email all slides to attendees early next week. Now, to introduce our speakers, Ed Grutzmacher and Sarah Queter. Ed Grutzmacher represents public entities and private clients in all stages of land use entitlements, from initial application through final administrative action. He also has extensive experience in litigation arising from land use entitlements, including cases involving CEQA, NEPA, the State Planning and Zoning Law, the Coastal Act, the Subdivision Map Act, the Cortese-Knox-Hertzberg Act, and the Mitigation Fee Act. Sarah Queter provides environmental and municipal law counsel for public and private entities. She specializes in water issues, particularly groundwater contamination, stormwater, wastewater, water recycling, and water rights. Sarah has worked extensively with the state and regional water quality control boards. That's all for administrative matters. I will now hand it over to Ed and Sarah.
Good afternoon, everyone. This is Ed Grutzmacher. Thank you again for joining us this afternoon for, again, as Christine said, the third in our series on legalized recreational marijuana, land use, and environmental laws. I am going to cover some land use issues regarding regulation of the new legalized marijuana businesses, and then Sarah will take the second half of the seminar and discuss some of the environmental law issues related to those businesses. Once again, if you were unable to participate in either of the first two series and are interested in getting notes or materials on those webinars, please let us know either by email or through the Q&A box, and we'll direct you towards those materials. Also, before I get started with the presentation, I just wanted to read our little disclaimer here. Myers-Nave represents both public and private clients who take various approaches to the issues surrounding medical and recreational marijuana. As our firm, our stance on these issues is neutral, and our goal is to help advance our clients' interests. Please note that today's webinar is educational, and the information presented in it should not be taken as legal advice. Additionally, we'd like to remind everyone that marijuana is still a Schedule I substance and illegal drug under federal law, and it is unclear how the new administration in Washington, D.C. will approach these issues, even in states that have legalized marijuana. So with that, I just wanted to start off. This is probably going to be review for most of you, but I just wanted to lay the framework here for what we're talking about in terms of local regulation of new recreational marijuana businesses, and just briefly and quickly go through an overview of the land use hierarchy, the various laws that apply to the regulation of all uses in local jurisdictions. The uppermost, the highest level in the land use hierarchy is, of course, the general plan, which governs development throughout the entire local jurisdiction. Going down from there, often, although not required, the general plan is a requirement. Every jurisdiction needs to have a general plan. Though not required, a lot of jurisdictions also have specific plans or area plans, which provide a little bit more detail in terms of development guidance in particular areas of the jurisdiction. Next, of course, after that is the zoning code. The zoning code establishes where in the city or county certain uses are allowed or not allowed, and under what circumstances those uses may be allowed or not allowed. And then finally, again, under the zoning code, certain uses are sometimes what are known as conditionally permitted uses, as opposed to permitted as of right. And those conditional use permits, conditional uses require a conditional use permit. So again, that range goes in scope from the broadest to the most specific, and also for purposes of regulating new uses or people coming in with applications to local agencies for uses and may want to change one or more of these laws to allow those uses, that hierarchy goes from the hardest to change to the easiest to change. So general plans are generally a lot more difficult to change. Zoning codes can be changed, but they're still difficult, and getting a conditional use permit is often sort of the easiest of the bunch. So under the Adult Use of Marijuana Act, the AUMA, well, under the Constitution, actually, local agencies have broad land use authority to regulate what types of uses are allowed within the particular jurisdiction, and the AUMA does little to change that. It's actually a very narrow area of things that the AUMA prohibits local agencies from regulating. Listed here are four of those items: personal possession, processing and transport, purchasing or giving away of marijuana or marijuana products for those 21 and over is generally something that local agencies cannot regulate. Also, personal use in a private residence by those 21 and over. Transport of marijuana or marijuana products using public roads, so you can't prohibit the trucks or vans or cars just driving through your city transporting marijuana or marijuana products. And also, the final one is you cannot prohibit personal cultivation of up to 6 plants per residence. That's not per person, that's per residence. Although that growth is subject to the reasonable local regulations on where and how those growths may take place. So, with those exceptions, local agencies can regulate pretty much anything and everything else as it pertains to marijuana businesses and recreational marijuana businesses. The caution here is that local agencies that do decide to ban commercial activities would be barred from seeking grant monies from the state that will be collected from excise taxes on marijuana businesses and collected specifically for purposes of use in, for example, local law enforcement agencies. Those local law enforcement agencies would be barred from collecting or seeking grant monies if the local jurisdiction decides to ban the entire operation. So as I'm sure most of you are aware, there are multiple license types available under the Adult Use of Marijuana Act. I'm not really going to go through these in any detail. The purpose of this slide and the next one is just to make sure everyone's aware that we're not just talking about cultivation and retail, and we're not just talking about indoor or outdoor cultivation. There are actually multiple different types of businesses that the AUMA contemplates. There are actually 13 different license types available for cultivation. In addition to indoor and outdoor uses, those include a category of uses known as mixed light uses, with the definition under the AUMA for what that means. And then another one in here, which is a little bit different from what I think the layman might consider cultivation, is marijuana nursery uses. In addition to that, there are 2 separate licenses for manufacturing. There are licenses for testing, retailing, and distribution, and for micro-business. And I just wanted to point out on the distribution, in terms of deliveries, one of these issues about what the local agencies can and can't regulate. I believe there's a little bit of a split in terms of deliveries. I think the prevailing view, and this is the view that the League of California Cities has taken, is that local agencies can ban deliveries to their cities. I just want to also point out, though, that new Business and Professions Code 26090C does state that a local jurisdiction shall not prevent delivery of marijuana or marijuana products on public roads by a licensee acting in compliance with this division and local laws as adopted under Section 26200. So it's a little unclear what that provision means exactly. I don't know if it's just duplicative of an earlier regulation that says you can't prohibit transport of marijuana on local roads, and similarly you can say you can't prevent deliveries from passing through your jurisdiction on the way to a delivery to another town, or whether that's actually saying, you can prohibit a delivery business from locating in your town, but you can't prohibit deliveries to residents in your town. Again, that interpretation is the minority view, but I believe that the statute is a little bit unclear on that, and we may be looking for more clarity on that as things move forward. So I want to start off with that background, talking about some local agency strategies for the regulation of marijuana. The first point, and I think it's probably the most important point that I want to make in terms of local agency strategies, is to make sure that you're regulating everything that you want to regulate. As I was indicating earlier, there are multiple different types of businesses that are allowed under the Adult Use of Marijuana Act. There are multiple different types of not only cultivation, but also manufacturing, et cetera. I think there's for people who aren't well versed in the marijuana business, which is probably most of us, we don't really realize the full extent of exactly what might go into that. And so if you're planning on regulating it as part of your land use code, your zoning code, we want to make sure that you are capturing all of the uses and all the different types of businesses that you want to capture in your regulation. If you're going for a blanket prohibition, for example, it's not sufficient just to say, we're banning cultivation and we're banning retail, because then you'll be missing some of these other types of uses. And in addition, depending on how you define cultivation, you might, for example, miss these nursery uses. The nurseries under the AUMA are essentially, what you think of with a normal plant nursery, except that they sell marijuana plants and seedlings and related items, which isn't what normal people would think of when they think of cultivation. Cultivation, people think of as growing things. And so if you're just selling plants and you're banning cultivation as it's typically defined, you might not capture a nursery use. Similarly, you might not capture all retail uses if you just ban marijuana retail, and you really wanted to also ban these micro businesses, which are both a combination of retail and potential for essentially tasting rooms or the ability for citizens to use marijuana in a private location. Also want to point out that in addition to marijuana, the plant, there's also marijuana products that are made, edibles and oils and whatnot, and marijuana paraphernalia as well, a lot of the equipment that people use for either growing or using marijuana. And if your jurisdiction is interested in a full blanket ban or even in regulating some but not all of these uses, it's important to realize, again, the full scope of the available businesses out there. So basically the full toolbox of land use regulations is available to local agencies in regulating the new marijuana businesses. Everything from complete bans, limiting uses to specific zoning districts, requiring uses to obtain conditional use permits. Again, these are just examples on this slide. The full toolbox is available to you. Things you might also want to consider, the AUMA has a definition banning certain uses near schools, essentially schools and daycares and other places where children might be located. The local agencies do have the ability to expand that definition. Local agencies do have the ability to expand the distance from those uses that you might want to locate marijuana businesses. You might also include operational restrictions, time, place, that sort of thing. So there are certain dangers of not regulating specific types of marijuana businesses. And I particularly want to emphasize to be aware of an over-reliance on permissive zoning. And for those of you who aren't land use gurus or do not know what the term permissive zoning means, generally a permissive zoning code says in certain terms that if a use is not specifically allowed for under the code, then it's not permitted. The problem with permissive zoning when it comes to marijuana regulation is a couple of things. One, if you do not regulate marijuana businesses and rely on your permissive zoning, and somewhere along the line the state determines that your permissive zoning is actually silent on a particular type of business, the state may issue a license to a particular marijuana business anyway because there's no specific local prohibition against that type of business. This is not like the medical marijuana where there's a dual licensing system. The states are the only ones that have to issue a license. Local agencies may issue licenses, but are not required to do so. And so the state's going to look when it gets an application from a marijuana business whether that particular business is allowed within the local jurisdiction. And one of the ways it might be allowed is if it got an approval, a CUP or whatnot. But another way it might be allowed is if it looks like it's allowed as a permitted use under one of the zoning districts or zoning regulations. And so, again, this can create confusion, especially with permissive zoning, and especially when it comes to the definitions of what's a marijuana use versus what's a regular use. For example, a lot of jurisdictions have land that's set aside for agricultural use. And if you are reliant on a permissive zoning scheme and you say we're allowing ag use in certain areas, someone might come in and say, well, my marijuana growing business is an agricultural business. It's an agricultural product. It's defined under the AUMA as an agricultural product. So I should, as of right, be allowed to grow marijuana in land that's zoned for ag use. Similarly, there's not really a difference in terms of land use designations between a retail business that sells books, for example, and a retail business that sells marijuana. Now, there may be certainly differences in the impacts to the local jurisdiction of those various types of uses. But again, if you're relying on a permissive zoning scheme rather than specifically regulating marijuana businesses the way you want to regulate them, you're going to run into issues with uses that might fit into a zoning district or a zoning designation as an ag use, as a retail use, as an industrial use, that would be permitted as of right. And if your code doesn't say that marijuana businesses are not permitted as of right, you may be stuck, accepting those businesses or fighting them later. So if your local agency does want to regulate and allow certain types of uses, one caution I would have is to be aware of an overconcentration issue. I think there's a little bit of a temptation to maybe shuffle these businesses into certain parts of a jurisdiction. Much like the ABC licenses that go out, the state's going to be looking at overconcentration issues when it comes to the location of marijuana businesses. So if your agency does want to, sort of put one foot in the water when it comes to allowing marijuana businesses in your jurisdiction, I would just caution to try and achieve a balance between, not putting these uses in a place that you don't want them. Obviously, you don't want them too close to schools or other places where children may be, but you also want to avoid sort of creating pockets of areas where only marijuana uses are allowed, which may cause an overconcentration issue. So I'm sure most of you are aware or have heard in the news, many local agencies are addressing the new marijuana landscape by first adopting a moratorium. Just sort of as an overview, moratoria are allowed, local agency can adopt a moratorium to temporarily halt any new businesses or uses while the local agency considers permanent regulations. This is usually a good tool to use, and a lot of jurisdictions have used that as a news item just yesterday. County of San Mateo had adopted a initial 45-day moratorium. Many other jurisdictions are similarly adopting these moratoria while they consider permanent regulations. The moratorium, again, can be 45 days for the initial period, and then you're allowed under state law up to 2 extensions, up to a total of two years. The first extension, the first moratoria is only allowed for 45 days. The second one can be up to 10 months and 15 days, and then you can go for another year. After that, the only caution on this is you can't use the moratoria as just a way of hoping it goes away. You do have to be working towards permanent regulations. The local agency does have to issue a report that shows what steps the local agency is taking to address the problem that allowed for the moratoria in the first place. So if you're on the business side of things, what sort of strategies can you pursue? Well, the first thing to do is to know where you want to operate. Pay attention, look at what the local agencies are doing in the place where you want to operate. So if you want to operate in a particular city or a particular county, pay attention to what's going on. What's the city doing? And another thing to say is honestly participate in the process. Show up and make your voice heard. I was just last night at a planning commission meeting in Sonoma County, a city in Sonoma County, not 20 miles from where the Emerald Cup was, and that city was discussing and planning on essentially instituting a blanket ban on all marijuana businesses within the city, and there was nobody there. There was nobody there at all to talk about that. And so, if there are businesses in Sonoma County that want to operate in that city, they're not going to be able to because they haven't been participating in the process. And so, if you are interested in pursuing a business, really pay attention to the notices that go out from the planning department, the planning commission, the notices that go out from the city council. Most cities and counties have websites. You can talk to specific planners about requesting notification if a city or county is pursuing or is going to consider particular regulations. And again, show up and participate in the process. Make your case, make your voice heard in terms of why you think your type of business is going to be beneficial for the jurisdiction and why you think it should be allowed. The other thing to think about if you're a marijuana business, looking into it is don't get discouraged by the adoption of early zoning regulations that do have a blanket prohibition. Hopefully you will have made your voice heard in certain situations, and maybe the jurisdiction decides to adopt your view, or maybe they don't. But also know that zoning regulations aren't permanent. Zoning regulations can be changed. They're changing them now. They can change them again. That said, be smart. Don't overcommit to a particular location if the type of business you want to operate in is not currently allowed in that location. And also, when you're looking at particular siting places for your business, try to avoid rezoning as needed entitlement. Again, as I mentioned sort of at the beginning, in that terms of that hierarchy, conditional use permits are, relatively speaking, easier to permit. Easier to get, but changing the zoning or changing the general plan to allow a type of use is much more difficult. So, and this is sort of under the category of strategies for both. I haven't seen a lot of discussion about this, but in looking at these types of uses and the landscape for these types of uses, it occurs to me that these types of uses are really ripe for development agreements. And for those of you who don't know what a development agreement is, it's essentially an agreement between a jurisdiction and a private entity to allow a particular type of development, and it's got benefits for both sides. For the developer, it allows for certainty in the development. It provides for vested rights. For the agency, it allows a lot of benefits. I say here you might test the waters with certain types of uses. It may be that you're a little nervous about getting into this, but you're going to open up a little bit of an area for particular types of uses. For for the developer, you may be able to convince a local jurisdiction to allow for a zoning change or allow for a particular type of use with a development agreement. It also allows for the imposition of more conditions on a particular project than would otherwise be allowed under the law. It avoids constitutional issues with takings in terms of the nexus on the conditions that you can put in there, and also allows for public benefits to go in with the development agreement. So, if you're a jurisdiction that's nervous about doing this, or if you're a business that's in a jurisdiction or wants to be in a jurisdiction that's nervous about this, it may be interesting for both sides to look at preparing a development agreement that's going to really spell out how this business is going to operate. What are the conditions that this business is going to operate under, and what are the public benefits that this business is going to bring to a jurisdiction that might be nervous about adopting or allowing for any sort of recreational marijuana businesses in its jurisdiction. Finally, in terms of strategies for both, I would just like to promote, consideration of alternatives between the two extremes. On the one hand, you don't want unlimited regulation. On the other hand, full bans. I think jurisdictions may be missing out on some of the benefits, including tax benefits and whatnot that may come with these businesses. I'm not saying, obviously it's a policy call for the decision makers, but just understand that when you're looking at these things, it doesn't have to be black or white. There's a full continuum of how much you're going to allow and what types of uses you're going to allow. Maybe you want to allow a retail shop. Maybe you only want to allow a retail shop that sells marijuana accessories. Maybe you do want to allow cultivation. Maybe you do want to allow manufacturing of some kind in specific locations. Just again, it doesn't have to be a black or white issue. And again, in the consideration of permanent regulations under local zoning, it's okay to have specific standards that are applicable to marijuana businesses. Another potential option is, and I think this is probably available for any type of zoning district, is, maybe you don't change the zoning code to prohibit marijuana, but you create an overlay zone that says, okay, under normal zoning, retail is allowed in this use, but if it's a retail marijuana business, then an overlay district applies, and these additional conditions and standards would apply to that marijuana business. And same thing may be true for ag or industrial or any of the types of uses that might be allowed. And finally, don't forget about CEQA. Last but not least, especially since I spend most of my life doing CEQA stuff. Don't forget about CEQA. All of this stuff is still subject to the California Environmental Quality Act. Development of your new zoning regulations are subject to CEQA. All specific projects are subject to CEQA. I'm still waiting for the argument to come in that your complete ban on marijuana businesses is going to increase traffic impacts because all of your residents are going to have to drive someplace else to get their marijuana. So I don't know if that'll happen or not, but I'm still waiting to see that one come in. And also don't forget that marijuana businesses are going to create a number of unique impacts for consideration under CEQA. If you are looking at permitting or allowing new marijuana uses to come in, the examples on the slide are just that examples, but again, there are a number of issues, especially involved with cultivation of marijuana. Water use is a big issue, odors. In manufacturing, sometimes some of the manufacturing uses use volatile substances, which could have hazardous substance impacts. Energy use, a lot of indoor grows have big energy problems. There might be public safety issues, especially with indoor grows, in terms of fire response, that sort of thing. Full gamut of environmental issues could be applicable to marijuana businesses, and you should, again, be aware of that as applications for businesses come in. And with that, I'm going to turn it over to Sarah, who's going to talk about some of the environmental laws that are applicable to these businesses.
Yes, thank you, Ed. Hi, everyone. Again, this is Sarah Queter, and I'm going to focus this part of the webinar on the environmental laws that affect marijuana, especially non-medical marijuana. Most of my discussion here will be geared towards cultivators, but that's not to say forms of local government should also understand these laws, especially from an enforcement perspective. So I find it interesting that the very first finding of Proposition 64, which is the Adult Use of Marijuana Act, states that in California, non-medical marijuana use is unregulated without any environmental protections, and I'm sort of paraphrasing there. I put unregulated in quotes because that word is rather somewhat of a misnomer, because in fact there are 40-plus years of environmental laws that have existed that all apply to this type of cultivation. I'm talking about the Federal Clean Water Act, the State Porter Cologne Water Quality Control Act. There's the Federal Endangered Species Act, the California Endangered Species Act, and other laws. All of these laws are important for cultivators to understand, as these new laws that are going to be developed as a result of proposition of the AUMA will come down the pipeline. So it's in Proposition 64, the AUMA adds this new layer of laws that will they'll need to fit into the existing legal landscape. So that's very important to understand. So as did the new laws that we do expect coming in the future, the AUMA sort of has a couple of requirements, and I've grouped them into two categories here. It requires state agencies to develop new environmental regulations and to also coordinate and consult with each other. Here I'm talking about the Department of Food and Agriculture, the State Water Resources Control Board, the Department of Fish and Wildlife, and the California Department of Forestry and Fire Protection. All of them will be working, and the Department of Pesticide Regulation. They will all be working together in developing these new environmental laws that will be on top of all of the existing environmental laws. Also, Proposition AUMA requires cultivators to comply with environmental laws as a condition of obtaining a license. So it's very important to understand the existing environmental laws and any new laws that come down the pipeline in order to not only obtain your license, but also to maintain your license. Your license could always be revoked if you violate those environmental laws. So all very important here to understand. I want to briefly touch on the environmental impacts associated with cultivation. First, let's talk about water supply. Here, I'm mainly referring to water diversion. Anytime you take water from a water body, you are creating a water diversion. Water diversions can reduce stream flows and therefore impact fish, wildlife, and other habitat. It also reduces stream flows, reduce water available for human consumption. If this occurs during summer months when the streams and other local water courses run dry, you can create fragmented streams and dewater the streams entirely. All of these impacts are compounded by a cumulative effect if there are many cultivators or other users of that same water source drawing from that same source. Because marijuana cultivation requires significant quantities of water, you can only imagine what a water diversion can do to a stream. So this is a very important impact. As far as water quality is concerned, cultivation can produce a whole host of pollutants. When we're talking about erosion, sedimentation from roads, we're talking about fertilizers, herbicides, and pesticides if those are over-applied. If we can talk about petroleum products associated with the use of cultivation equipment. Any of these pollutants can be carried to a nearby water through irrigation runoff or stormwater. And that water, those impacts, those pollutants can therefore degrade water quality, harm fish and wildlife, and those are generally, there's quite a bit of impacts there. Soil impacts are also prominent when you talk about spills or over-application of fertilizers, herbicides, and the like. Those can, of course, contaminate your soil, but some of those can also percolate into the groundwater and affect any potential uses of that groundwater. Drinking water, for example, anybody with a nearby drinking water well should be concerned about potential contamination of their drinking water supply if any sort of toxic chemicals from over-application of pesticides leach into their groundwater. All of these impacts also affect species and habitat. Certainly, the diversion I mentioned, when there is very little water available for fish or habitat. There's also the water quality, the water pollution. Certain toxic chemicals can create fish kills. And then, of course, there is land development and tree removal in order to create your grow farm. All of that, if you destroy the habitat of wildlife, that also is very problematic. It can, by clearing the trees, you also reduce the shade, you can increase the water temperature, lots of impacts there. And then finally, the carbon footprint associated with indoor cultivation. Indoor cultivation is a very energy-intensive process, and because of marijuana cultivation, at least from the non-medical standpoint, was previously deemed illegal, growers have been using inefficient off-grid gasoline and diesel generators, which certainly burn fossil fuels and contribute to climate change. So it's certainly an issue. Let's wonder whether, now that the AUMA is on the books, if the cultivators will now connect to the grid and the utilities which have energy conservation programs or a mix of renewable energy sources will help to be able to reduce those fossil fuels. Now I'm going to get into all of the various existing laws that apply to cultivation. Now, the threshold question here is, does your city, county, or zone allow for marijuana cultivation? This is what Ed was just talking about in the first half of this webinar. Each city and county has planning and zoning rules which regulate land use. And so if marijuana cultivation is not prohibited in your area, then you will need to obtain, most likely, a county grading permit, which is necessary to control erosion, sedimentation, and to prevent damage to water courses. And those county grading permits usually require an erosion control plan. So at the very local level, you will first need to obtain a county grading permit. Now let's talk about water supply. If you do plan to divert or take water from a surface water body, let's talk about a lake, river, stream, or creek, then the California Water Code requires that you have a water right. Water rights is a very complex area of law, so I will be very provide a very 30,000-foot level overview here. A water right is a legal permission to use a reasonable amount of water for a beneficial purpose. There are three types of water rights, two of which are more common, which are the riparian rights and the appropriative rights. Riparian rights are essentially tied to land that sort of is adjacent to a water course. You can use that water as long as you return it directly back to that lake, river, or stream. Appropriative rights are essentially rights that are not riparian. Prescriptive rights are more of a squatting type right. In any case, in order to have a water right, if it's not riparian or if it's not an appropriative right that predates 1914, I know that's quite some time ago, then you need to apply for a water right permit or license. This Division of Water Rights, which is part of the State Water Resources Control Board, oversees the whole water right permit process, and they will only grant water right permits if there is a reasonable likelihood that water is available in that given watershed. There are various water courses in the state of California that are already fully appropriated and no more water is available. I will say that using water without a water right is therefore considered a trespass against the state, and it can lead to fines of up to $500 per day. You might also need other permits from other state agencies in order to obtain your water right. What's interesting here is that the AUMA requires applicants for cultivation licenses to identify the source of water that you will be using and to certify that you have a legal right to use that water under state law. So certainly the water rights is a very important threshold necessary to obtain your cultivation license. Let's talk about water quality. So there are two primary laws here that apply to water pollution, water quality. The Federal Clean Water Act and the State Port of Cologne Water Quality Control Act. The state and regional water boards are the state agencies in charge of administering these laws. And if I could summarize here, under both federal and state law, it is illegal to discharge a pollutant to a water body without a permit. Now that's a huge oversimplification, but because there are various differences between the federal and state law, but that is essentially what is necessary here. The National Pollutant Discharge Elimination System permits, NPDES, those are the federal permits, and in this situation, you would probably need to obtain a stormwater permit when you are building and disturbing land in order to create your grow area if it's greater than 1 acre in size. That's a stormwater permit there. Otherwise, there's a bunch of different types of state waste discharge requirements or conditional waivers of waste discharge requirements that are applicable. And interestingly, in California right now, there are 2 regional water quality control boards that have issued, I guess I will call them permits for marijuana cultivation. One is the North Coast Regional Water Board, which has issued a conditional waiver of waste discharge requirements, and that doesn't mention whether it's applicable to medical or non-medical use, and so it would apply to both. The Central Valley Regional Water Board has issued waste discharge requirements, and has specified currently that those waste discharge requirements only apply to medical marijuana cultivation. So we'll talk about how non-medical cultivators will deal with that in Region 5 soon. Both of these permits, so to speak, operate under a tiered framework based on your threat to water quality. They look at criteria such as the size of your operation, your proximity to surface water, and the slope of your land. And both also contain numerous types of best management practices and standard conditions that you must comply with during the operation of your cultivation. Another permit I will mention here is another federal permit under the Clean Water Act. It's called a 404 permit, and it's issued by the U.S. Army Corps of Engineers. And this is if you want to dredge or fill any wetlands, and that's, again, an oversimplification. There is a nationwide permit number 40 that is one of these 404 permits that applies to agriculture. There are exemptions from this for certain types of farming activities, and query whether marijuana cultivation would fall within that exemption, but that is one type of permit, 404 permit, that you would need to obtain from the Army Corps, depending on what you will be doing with the wetlands. But these are all conditions and requirements under federal and state law that you must comply with in order to obtain and maintain a cultivation license. Now, with respect to species and habitat, if your cultivation activity is likely to adversely affect an endangered or threatened species that is listed under a federal list or a state list, then there is both the Federal Endangered Species Act and the California Endangered Species Act that would apply to you. Both acts have a process of what's called consultation, which is basically a process to determine what effects, if any, your activity will have on the listed species. If there is, after quite a bit of process here, it's determined that you can proceed with your activity, then you are likely to be able, you would obtain what's called an incidental take permit. A take is actually a term of art, and under California and federal law, the definitions are slightly different, but in essence, it is illegal to hunt, kill, capture, or disturb one of the listed species, again, endangered, threatened species. This also has been construed to apply to habitat as well. Excuse me. So in essence, you would have to obtain an incidental take permit, of course, after, if the consultation reveals you are able to proceed with your activity. Under federal law, there is also a habitat conservation plan that is something that you would have to develop in conjunction with your incidental take permit. There are, under state law, the California Department of Fish and Wildlife also has various pollution prohibitions that prohibit the discharge of various types of chemicals and pesticides into a water course that may harm fish and wildlife. And then also there is something called a lake or streambed alteration agreement that you will need to obtain if your activity would result in the modification of the natural flow of any river, stream, or lake. So you will need to notify the California Department of Fish and Game prior to commencing cultivation if you do plan on, let's say, substantially diverting water, and you will need to obtain this lake or streambed alteration agreement. This type of agreement will include measures that are necessary to protect existing fish and wildlife resources. And then finally, I want to mention the timberland conversion permit. In essence, if you plan on removing certain types of tree species, you will need to contact the California Department of Forestry and Fire Protection and obtain most likely some sort of, I know there's some sort of exemption permit, but there's a timberland conversion permit that will allow you to do this. And all of these documents must be prepared by a registered professional forester, and all the operations must be conducted by a licensed timber operator. So you have a permit there that you might need if you're clearing your land to prepare for cultivation. Well, now we can talk about pesticides. So pesticide use in the United States is governed by the Federal Insecticide, Fungicide, and Rodenticide Act, called FIFRA, and this establishes a goal of preventing unreasonable adverse effects from pesticide use. FIFRA is implemented in coordination with the Federal Food, Drug, and Cosmetic Act. And that act establishes tolerance limits for allowable pesticide residues on specific crops, unless that agency determines the pesticide is exempt from a tolerance limit. So at the present time, there are no pesticides or herbicides registered specifically for use directly on marijuana. And that is likely because marijuana is still illegal under federal law. And so what happens here is if there is no pesticides currently registered for marijuana, you have to look to state law. And under California law, you are not allowed to use any pesticides on marijuana unless your pesticide is exempt from the residue tolerance requirements as a minimum risk pesticide under FIFRA and also the state law, and either exempt from registration requirements or or registered for use that is broad enough to include use on marijuana. For example, unspecified types of green plants. So that's the universe of the existing laws. I'm sure I've missed a bunch, but there are other laws that I have not covered here. But those are some of the primary laws to keep in mind when you are operating your cultivation business. Now, the additional laws on the horizon that the Adult Use of Marijuana Act is requiring there's various levels here. So a new Water Code Section 13276 states that the water boards may adopt permits that address all these various aspects of cultivation here, from erosion control, water storage and use, your fertilizer use, any sort of petroleum products, refuse and human waste, cleanup, restoration, and mitigation. The Region 1 and Region 5 permits that I mentioned that are already on the books already address these, but now it's codified under Water Code Section 13276. And so we certainly expect to see this coming down the road. It will be interesting to see what the regional boards will be doing I imagine that Region 5 will need to develop a new iteration of its waste discharge requirements because those currently only apply to medical use. And other regional water boards may follow suit. We also might expect the State Water Resources Control Board to issue a general statewide waste discharge requirements, which would make it slightly easier so that this way the regional water boards wouldn't necessarily need to adopt their own individual waste discharge requirements for their regions. And so it might be very possible that the State Water Board will be developing this general statewide permit in the near future. With respect to other state agencies, the AUMA specifically calls out the Department of Fish and Wildlife, the Department of Food and Agriculture, and the Department of Pesticide Regulation for the development of regulations related to environmental impacts of cultivation. For example, the Department of Fish and Wildlife may develop regulations for interim flows. This is talking about water diversion here specifically. The Department of Food and Agriculture will be required to include conditions in your cultivation license that is requested by both the Department of Fish and Wildlife and the State Water Board. So you'll need to comply with those conditions in order to, of course, maintain your license. And then because right now we don't have pesticide that's directly applied to marijuana in California, the Department of Pesticide Regulation will need to consult with the Department of Food and Agriculture to develop those standards. And also the State Water Resources Control Board will consult on that as well. Lots of new laws. It's quite an uncertain territory, but we do see a lot coming down the pipeline. So some of the other issues, this is my last slide, to think about when we're talking environmental laws is there's going to be a lot of coordination among all these various state agencies in developing regulations. It's going to be interesting to see, where there might be some ambiguities between various state agencies, and so coordination will be very important here. Another question is, the intersection with medical marijuana. We already have the Medical Cannabis Regulation and Safety Act, and to what extent would any of those laws intersect with, as far as environmental regulations, require any modification to comply so that everything is covered under one umbrella, so to speak. Enforcement is going to be an interesting question. I know from experience through working with the water boards that the water boards typically use a progressive enforcement approach, that anywhere from a very informal notice of violation to obtaining something like an actual administrative enforcement order, seeking an imposition of civil or administrative penalties for violating the state and federal water laws, at least. And then lastly, what's going to happen with the new administration? Right now, we know through the Ninth Circuit opinion that came out in August that the U.S. Department of Justice is prohibited from prosecuting those who engage in state-sanctioned use of marijuana laws. But who knows what will happen? Right now there are a total number of 29 states that have legalized, at least for medical marijuana use. So we don't know what will the U.S. Attorney General do under a Trump administration. We have seen that Trump has seems to be wanting to take a hands-off approach and leave the issue to the states. But who knows whether any of that will come into play. So that concludes my portion of the presentation. I think it is now time for questions. And recognizing that it is just about 1 o'clock, we did start a few minutes late. So hopefully those of you can stay on the line for questions.
Thanks, Sarah. And we did get a few questions. Obviously, we're not going to have time quite to address all of the questions that came up. And again, if we don't address them orally here in the next few minutes, either Sarah or I will respond to you via email or telephone call within the next week to address any questions that you might have. I did get a couple of questions about the definition of micro businesses under the AUMA. Micro businesses are defined at Business and Professions Code 26070, subdivision A3, and it is sort of an odd definition. It provides for the cultivation of marijuana on an area less than 10,000 square feet and to act as a licensed distributor, level 1 manufacturer, and retailer under this division. And again, level 1 manufacturing is for non-volatile solvents. So I think that the concept here is, a pot shop that grows its own and maybe makes its own, edibles or whatnot, and also sells them within the same facility. So that it's a small growing facility, but not so large as to reach, a general cultivation permit. Just kind of allows a one-stop shop for marijuana businesses. There was a similar question about whether a marijuana accessories location is required to have a micro business license. I do not believe that that's the case. Again, as the definition I just read for micro business, it doesn't seem to indicate that you have to cultivate in order to sell marijuana accessories, which is a separate definition. If you want to have a micro business license and sell marijuana accessories in addition to other business items, then yes, you would need a micro business license, but I don't think it's a requirement. A second question I had was with regard to the effective date of moratoria. The moratorium, when it's adopted, is good for 45 days. There's a little bit of debate, and it depends on exactly what you're talking about, whether or not they can be retroactive, but for whether you can make them retroactive or not retroactive, the first period can only be for 45 days. So even if you set it back 15 days, then it's only going to be good for an additional 30 days if you were to decide that it could be retroactive. If it wasn't retroactive, then it's good for 45 days the first time, and then the local agency would have to decide how long that second extension is going to be. Again, the maximum extension for the second extension is 10 months and 15 days, so bringing it out to a full period of 1 year. And then you can adopt a second extension, which you can put out for another year, but again, you can only adopt 2 extensions. So that's that for the effective date. And then I had a question regarding, this one's for Sarah. What if your project requires a federal permit, but the federal agency under the new administration does not allow it?
I'm sorry, you wrote that down. The federal agency, a federal permit, but the federal agency
does not allow
it. So that's an interesting question. Who knows what will happen there? Ultimately, the federal permits that there's 2 that we were talking about here. The first would be a National Pollutant Discharge Elimination System permit for the discharge of stormwater associated with construction activity. That is what you would probably find for cultivation of marijuana here. And that permit is issued by the State Water Resources Control Board. The State Water Resources Control Board has authority from the U.S. Environmental Protection Agency to issue these permits. And so through state law and the water code, I don't see an issue there as far as that permit being allowed, because but again, it depends. If the new administration completely bans state laws, then certainly that's an issue. We'll have, or at least would prosecute those. It's a huge area of uncertainty. The other question is the 404 permit issued by the U.S. Army Corps of Engineers. As far as the issuance of a nationwide permit or perhaps an individual 404 permit that pertains to your cultivation operation, if you plan on dredging or filling wetlands, that's certainly also subject to uncertainty, because if the Trump administration says, okay, U.S. Army Corps, you are not allowed to issue any sort of nationwide permits to a marijuana operation or dredge fill, and then what will happen there is you will not be able to obtain your cultivation license, because a 404 permit, if you do plan on dredging and filling in your area, is a precondition for compliance with some of the other environmental laws. You would have to either relocate your operation so you are not dredging or filling a wetland, or wait to see what will happen as far as the administration is concerned. But ultimately, if you do dredge or fill a wetland without a 404 permit, then that is a violation of the Clean Water Act.
Yeah, and again, just piggybacking off of that, I think that the best advice is until the landscape becomes more certain, try to avoid siting or planning your project in a way that's going to require a federal permit. So we've hit 1:05. I'd just like to thank you all for your time this afternoon. I know there's a number of questions that we didn't get to, and we will, again, try to address those as soon as possible. If you guys think you have other questions that you didn't get a chance to ask, feel free to contact Sarah or I, and we'd be happy to answer them. And again, thank you, everyone, for your time.
Yes, thank you very much. Have a good day, and happy holidays.
Thank you.